Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content. And today is the day I earned that subscription. For today's story, we are dealing with Puerto Rico and how much protection Puerto Rico has as a jurisdiction. So this deals with sovereignty and their protections as a sovereign. We live in a federated republic. The United States is sovereign. Each individual state is sovereign. And this dual sovereignty leads to many of the interesting complications of United States laws because states can sometimes invoke sovereign immunity for protection. But how about a place like Puerto Rico? Puerto Rico isn't a state. It's a territory. It is an enclave. It is part of the United States, but not any state. So is it the same thing as the federal government? Does it have any protection unto itself? What are the limits of this protection if it does have any? How do we treat the issue of Puerto Rico sovereignty in this federated republic of ours when Puerto Rico is a territory? Well, the Supreme Court is grappling with that issue right now on a media lawsuit that could have tremendous implications for the territory because depending on how the Supreme Court resolves it, dealing with the insular cases, for example, perhaps Puerto Rico might get even more protections than they ever have before. Maybe this will be a watershed moment for Puerto Rico and its protections under the Constitution. But let's learn a little bit more about this case. Puerto Rico's status as a U.S. territory took center stage at the Supreme Court as the Supreme Court considers whether its congressionally approved oversight body is entitled to the same kind of immunity from lawsuits that U.S. states have. The justices heard oral argument in an ongoing feud between an investigative journalist and the board established under Puerto Rico's Oversight, Management, and Economic Stability Act. The act was adopted by Congress in 2016 to create oversight for critical restructuring of Puerto Rico's $74 billion debt. So Puerto Rico's had some financial problems, and because they're a territory, well, that makes it the United States' problem, as opposed to individual states where they're responsible for their own debt. So, if you're California and you have debt, you figure it out. Because Puerto Rico is a territory, well, that makes it a little bit the United States' problem. The investigative media company, for its part, often covers activities under this act, and in doing so, sought records to increase transparency of the board's operations as part of the massive debt structuring process. So, maybe a good laudable goal, but we'd like to get access to some records, perhaps some internal records of this management agency. In terms of how they're doing this. How are they doing this? Can we see the internal deliberations? Normally, not so much. But then again, Puerto Rico is in its own special class. The board refused to turn over documents to the media entity, and the organization sued. The courtroom matchup, however, has turned little on the watchdog function of journalism, but instead on the issue of sovereign immunity. So if you're trying to sue a state, you have sovereign immunity problems. Right? You either have to find an exception in state-specific law, or you have to find some federal hook or something, right? But often you can't get information, particularly as it relates to internal deliberations. For example, that wouldn't be discoverable under the Freedom of Information Act. You can't get internal deliberations of an agency, for example. But you want to get this from a state. Well, sovereign immunity. But wait a second, it's Puerto Rico. Puerto Rico is not a sovereign. Or are they? I'm confused. How does this work? Let's read more. Although the Puerto Rico Constitution gives the public a right to access to public information, which is interpreted similarly to the Freedom of Information Act, the board has argued that under federal law, it is a right to sovereign immunity from the lawsuit, and that grave harm would result if it was forced to turn over the records. Therefore, in Financial Oversight Board versus the media entity, the court is considering the question of whether the Oversight Board was ever entitled to sovereign immunity from the claims, whether the immunity is gone, and whether the board is exposed to the lawsuits. Both the district court and the First Circuit have ruled in favor of the media entity, finding that the Congressional Act board was not protected from the lawsuit because Congress has abrogated its sovereign immunity when it created the board. So this is not a separate state. This is Puerto Rico, and Puerto Rico is the federal government. Maybe, right? So therefore, because Puerto Rico is the federal government, if the federal government waives sovereign immunity, well, Puerto Rico has nothing left. Puerto Rico is trying to argue it has something left. Puerto Rico's status as a territory rather than a state or nation, creates an important distinction for much of the sovereign immunity case law. Typically, sovereign immunity disputes involve standard tension of federalism, because you do state immunity, federal immunity, congressional action, congressional oversight, congressional preemption, all kinds of fun stuff. Other sovereign immunity cases involve lawsuits against the federal government, and of course, foreign sovereign immunity deals with foreign nations. So if it was a foreign nation, there's a foreign immunity. If it's the national government, federal immunity. If it's a state government, state immunity. But Puerto Rico's none of those things. So the Investigative Journalism Board, or the Investigative Journalism Outlet, points to its brief that a territory would have lesser claims to sovereign immunity because the territories lack independence and therefore are subject to congressional control under Article 4 of the Constitution. Sovereign immunity has been a subject of interest to the United States Supreme Court as of late. The idea that independent sovereigns such as a state, the federal government itself, or a foreign country would be immune from defense is not unqualified. So it's not just something you can invoke and be done with it. It's a little bit more complicated than that because, of course, that's the nature of law. The High Court has recently considered cases involving immunity for states, the U.S. military, foreign countries, Native American tribes, and foreign corporations who may be considered agents of the foreign country under the Foreign Sovereign Immunity Act. The Biden administration supports the Act's argument in favor of immunity. In its amicus brief, the court has argued that as a territory, Puerto Rico is not encompassed within the 11th Amendment, which speaks to sovereign immunity of states. Nevertheless, this court has long recognized that the government established in Puerto Rico is sovereign, and entitled to sovereign immunity, it prevents the tribal government from being sued without consent. That immunity parallels sovereign immunity of the United States, the states, and Indian tribes, and like the immunities of those entities, it may be abrogated only by a clear statement of Congress. So the federal government, for its part, has said that, well, the case law is such that Puerto Rico has been treated as though it were a sovereign entity, like states, which I can't really speak too intelligently to that particular claim. Not something I have extensive knowledge about. But yeah, there is an issue there. And there is perhaps, this isn't a case with the case law, but perhaps the case law should change. Justice Sonia Sotomayor, who is from Puerto Rico, led the lawyers through an analysis of what she called tremendous implications for Puerto Rico. Sonia Sotomayor says territories like Louisiana's and others didn't have sovereignty before they became territories of the United States. And historically, no territory was dragged into federal or territorial courts unless their sovereign had been waived, correct? In our 200 years of history, Justice Holmes' proposition that no sovereign, by which he meant no governing entity, would be dragged into court without the consent of the sovereign. So Sonia Sotomayor thinks that, well, this is how we've treated other territories in the past. Maybe it is, maybe not. Again, a little outside my wheelhouse of knowledge, not super knowledgeable on the implications of sovereign immunity for territories of the United States throughout history. But that's why you, as an attorney, when you get one of these things, you get to just do all the research, right? You don't have to know this in advance. That's why you just go all the research and then you become a master of it. And then you educate the courts about it. So it's an interesting case to be sure, because, you know, how we treat Puerto Rico should probably be similar to how we've treated other territories in the past and issues dealing with precedent. So it's fun. Sonia Sotomayor then brought the analysis to its core and confirmed with the lawyer, to the extent the U.S. hasn't permitted or entertained it looked at suits against the territories, they've acted akin to states. We've said Puerto Rico is like a state. Chief Justice Roberts raised a point of contention in his next question when he asked Harris, does the 11th Amendment say states or things like states? So maybe Puerto Rico / Louisiana / whatever have gotten more protection in the past than they really do. Maybe this is not what the Constitution requires. Justice Neil Gorsuch, talking to the assistant for the Solicitor General, raised concerns, asking, have you considered how your view of sovereign immunity might apply to other territories beyond Puerto Rico? The attorney who was arguing on behalf of the CPI to the court said they should reject the use of clear statement rules when making its decision, facing tough questions from the bench. The rule, which had been used in past cases, says Congress can only abrogate sovereign immunity by making a clear statement. You're analogizing Puerto Rico to a municipality, but it's not. Because if it were a municipality, if it were a city, the sovereign immunity would belong to the state. All right? Municipalities are not sovereign. They are creatures of the states in which they live in. States have the right to control municipalities. The degree to which they do, as a matter of their own state law, is of course for their own preferences. Some states give counties / towns / cities quite a lot of autonomy. Some don't. But ultimately, every state has the power to do whatever the hell they want. They can just abrogate. They can create and destroy counties and cities at a whim, because those cities and municipalities and counties have no recognition beyond what the state law allows for. So they can always amend their state constitution or amend their state law and ultimately do whatever the hell they want. But yeah, if it were a municipality, we'd be talking about sovereign immunity because we'd be asking about the state's level sovereign immunity. But Puerto Rico's not a municipality. It's not a state. You've not given me a reason why Puerto Rico should be treated differently than Indians, differently than territories, said Sotomayor. The Chief Justice took issue with the attorney's statement that the court should abandon the clear statement rule. You said the clear statement rule would interfere with Congress's power, commented the Chief Justice. I don't quite understand that. It just says it has to be clear. Maybe we should apply that rule across the board, Roberts joked, asking it doesn't prevent Congress from doing whatever it wants. Justice Jackson appeared to agree and saying Chief Justice makes a good point. It's not really about restraining Congress in any way. I understood the clear statement rule is to prevent us from finding something when it's crystal clear that Congress didn't intend it. So yeah, Congress, much like the states, can control the territories and kind of can do whatever the hell they want. So maybe it's just an issue of Congress speaking clearly or not. So maybe the issue is that the United States hasn't waived its immunity, and Puerto Rico is just the United States. And so maybe that's the right way to look at this. So we don't have to look at the issue of Puerto Rico having sovereign immunity or not. We can just look at the issue, well, is the United States' immunity or not? And what did Congress do? And we're going to require them to speak clearly. It's one of those things that we're going to require to be really direct if we're going to do this. So we're not going to infer it, which, fair enough. We're just going to interpret statutes a little bit more closely and a little bit more carefully to Congress's intent, which, maybe you should be doing all the time, quite honestly, but that's the current argument that's being had. Sotomayor then shifted the conversation to underscore the importance of the court's rulings. Others are going to sue Puerto Rico on other claims beyond the one that's being raised. Yes, one would imagine. Sotomayor told the lawyer, adding that if the court finds Congress intended to abrogate sovereign immunity, that finding will control. Yes, that would be true. If Congress abrogates sovereign immunity, then they abrogate sovereign immunity. They will be sued and can be sued for all the things for which the sovereign immunity has been waived. Questions about the limits of Puerto Rico's sovereignty were also before the Supreme Court in 2016, though that case was not about immunity from private lawsuits, but rather double jeopardy. In the court's decision, the justice ruled that Puerto Rico is not a separate sovereign for the purposes of double jeopardy because it's the United States, and therefore a criminal defendant could not face successive prosecutions. Thus, that brings us to the end of this fascinating case dealing with sovereign immunity and Puerto Rico and its status as a territory, and what independent sovereign immunity it has as a territory, if any at all. Because it's not a state, so it's not protected by the 11th Amendment. It's not a foreign nation, so it's not protected by the Foreign Sovereign Immunity Act. It's a part of the United States. And so maybe it has no immunity except what the United States has, which defaults it into immunity, incidentally. Congress would have to expressly waive it. But it's something that perhaps that's the case. So maybe Congress, so you have two questions potentially here. Did Congress waive the immunity? Right? So if they didn't waive the immunity, then you can just solve it that way and just say, okay, they didn't waive the immunity, so no big deal. If they did waive the immunity, then you have to say, well, does Puerto Rico have anything left independent of that? And since Puerto Rico is a territory and subject to governance under Article 4 of the Constitution, presumably the answer is no. Presumably Congress can do whatever the hell it wants, and then it just becomes a question of did it do whatever the hell it wants? And so that would seem to be the right answer. But a really interesting case also because it has some implications for the insular cases and to the degree to which the Constitution does or does not apply to Puerto Rico in full or in part, always a fascinating topic for Puerto Rico. So a lot that's interesting that's happening there, at least for a moment. That brings us to the end of consideration of this case.